Welcome to the Plant Grow REAP podcast.
Welcome to Plant Grow REAP. I'm Elektra, and with me today is estate planning lawyer extraordinaire Sophie Cohen.
Hi, everyone.
And today we're going to be talking about estate planning. So I met Sophie about a year and a half ago when I joined Aintree Group Legal, and I've been working as your legal assistant ever since.
Yes.
And so, Sophie, can you tell us a little bit about how you got into estate planning and why you chose to specialise in it?
Well, I'm super excited to be here today because I get to talk about something I'm very passionate about and I love talking about. So thank you for having me. How did I get into it? I've always had a very general legal practice. Back when I started, 28 years ago or something like that. Specialised more in commercial litigation when I first started out, as a lot of young people do.
Yeah.
Estate planning, I think, is not a very glamorous area of law. I don't think anyone goes to uni and thinks, oh, I'm going to be an estate planning lawyer. But then I stopped practicing law for about 8 years and did some other things while I raised my 4 beautiful children. And when my youngest was at kinder, an opportunity came up to work with a financial planning and accounting firm. And so that's where I started really getting into the more bespoke, sophisticated estate planning area, because estate planning jigsaws in very well with those 2 other disciplines of financial planning and accounting, which is why we have an integrated practice here at Aintree Group. So I started doing a lot of estate planning then, and I hadn't specialised in it much previously, so I thought, well, I'll go and do a master's in it. So I did my master's at the College of Law, specialising in estate planning, majoring in estate planning. And I also thought, well, the best way to learn is to teach. So I lectured in wills and succession at RMIT in their Juris Doctor program, and that's how I really developed those skills, as well as just working day-to-day with accountants, financial planners and their clients. So the reason why I'm driven to really work in this area, though, is I just love the little snapshot of people's lives that you get and the opportunity to really get to know them as families, the family dynamic, the broader family, and what their values and objectives are. And if I can play a part in formulating a legal estate plan or that legal infrastructure that can support what they want to achieve for their family in the future is really special.
Yeah. Okay, so talking about our clients, so if a client walks through our doors and needs help with their estate planning, can you walk us through how you would approach that, what the meeting would look like, and what documents you might put in place?
Well, I think the first really important thing is to connect with the client and get to know them. Work out, how they're structured, but get to know what their values are, their family, the dynamic between them, and what they really want to achieve out of it. I can very easily say, oh, this is the legal structure that I think you should put in place, and these are the benefits that you'll get from it. But sometimes that's not what a client wants. So you really need to listen to the client and have that frame the whole relationship going forward. I think a common misconception is that estate planning is just doing a will. And so that's probably one of the first things that I really reframe with clients, that it is more than just doing a will. There are blended families. Most families have some sort of other structures, even just superannuation, which might not necessarily form part of your estate. They might have family trusts or companies run their own businesses. And so it is more than just doing a will, because your will only cover or govern what will happen to the assets that you personally own and form part of your estate. So we'll look at all those other structures and we'll also look at putting in other documents that operate while a client is still alive, but perhaps can't make decisions for themselves. So enduring powers of attorney for financial and personal matters, appointing medical treatment decision makers, making sure superannuation is directed in a way that aligns with what the client is trying to achieve with their estate plan. And normally we would do all of those documents as a suite of documents or a package rather than just look at a will in isolation.
Yeah. So if I need to get my estate planning done or I just want to make a will, why would I come to an estate planning lawyer like yourself when I could instead pop down to like Australia Post and buy one for $70? Like, what makes us so special, I guess?
Well, we are special, but that's a really good question. In the past, I've always said having a will is better than having no will.
Yeah.
So even if it is an off-the-shelf will, or there are lots of online options available as well now. Things are so much more accessible. You could Google, or Chat GPT, write me a will, and it would probably do it. So in the past, I've said any sort of will is still worthwhile. It's better than having no will. But sometimes it actually can have the opposite impact and distribute your estate in a way that is quite contrary to what you want, because you might leave out assets, not have an understanding of what actually forms part of your estate and what you can leave to someone else. For example, jointly owned property you can't leave to anyone under your will. Jointly owned property will automatically go to the surviving owner. So I think if you just do it yourself, do a DIY job, then you won't have an understanding of what forms part of your estate and making sure that all of it is distributed in the right way, that the right people are appointed to act as your executor. And we often see problems with just the validity of signing. A will needs to be in writing. It needs to reflect your testamentary intentions, so what you want to happen when you die. And it needs to be witnessed by two adult witnesses. So, and even though they'll have those instructions in a will kit, often they're not followed or not followed properly. In fact, a former colleague of mine contacted me, must have been about 6 months ago, just to verify that, because it was such a bizarre situation, that this in fact was not a valid will that had been witnessed by the woman's cat. So her cat had put a paw print as the witness to the will. Now, that's an invalid will. Might still be admitted to probate as an informal will, but those little technicalities, because technicalities are really important with legal documents, those technicalities can be missed.
So when we're designing people's wills, we sort of have two main approaches. So could you walk me through like what the difference is between those two style of wills?
Do you mean in terms of whether we just keep it a simple will?
Or say implement something that's maybe a bit more advanced, like testamentary trusts.
So anyone who's heard me speak before will know that I talk a lot about testamentary trusts. And they're not for everybody, and it's not like I push them on clients either, because it's sometimes there will be a situation where it's not necessarily appropriate. But essentially what a testamentary trust is it's a trust, a bit like a family trust in a lot of ways. It's normally discretionary, although it can be tailored in specific ways to control how capital's used, etc., or be a more protective trust. But it's essentially a trust created under your will. It doesn't come into play until you die. And as part of the estate administration, applying for probate process, the trust would be set up. And it can have some really powerful benefits for clients, because by leaving your estate to a beneficiary, so to a loved one, say a child, in a testamentary trust structure, where a trustee, and it might even be the beneficiary themselves if they're an adult, independent adult, making sensible decisions, that controls the trust in terms of what they invest in, managing the day-to-day operations of the trust, and distributing income. So one of the powerful benefits is being able to distribute income not just to your child, the beneficiary, but also to a range of other beneficiaries. So that might be your child's children, so your grandchildren, or it might be other entities that your child's associated with, like their own family trust, for example. So they can manage the estate in a really tax-effective way by distributing income or splitting income amongst a range of beneficiaries. And it's also keeping those assets in a really protected environment. So that will be certainly one quite sophisticated estate planning option that we will discuss with clients when they come to us and put it in place as part of the will.
Yeah. So, I mean, for myself, when I first started working here, and probably also for our listeners, I came in and I'm just hearing trusts. And I guess like I'd always associated trusts with only being put in place for people who have like vast quantities of wealth or say,
Just
quote
for
unquote,
rich
like
people.
rich people. Yeah. So I was surprised that maybe clients, like they're for also just the everyday person as well.
Yeah, because there can often be other objectives with creating a trust.
Yeah.
It might not just be to obtain that financial benefit or tax effectiveness of the structure. First and foremost, trusts are very protective, because the assets aren't in someone's personal name, they're in another structure. So it's protected from a lot of outside influences.
Yeah.
So in terms of creditors or bankruptcy, it's protected from that. So if you've got a beneficiary, a child that's in a really high-risk occupation, for example, or isn't really good with money and gets themselves into financial difficulty, the assets that you've worked really hard for all your life to accumulate are more protected in that environment. Also from a family law point of view, and this is a concern of a lot of clients who have adult children. They'll come to me and they'll say, look, as much as I love my son-in-law, I don't want everything I've worked my whole life for to end up 50-50 between my son-in-law and my daughter if they divorce down the track. And with a testamentary trust, the assets that are in that trust are much more protected from that family law perspective. So the family court might say, they might ignore them completely, or they might see them as a resource for the daughter in this situation, but they won't group them into the pool of assets that are divided between the parties in a matrimonial breakup.
Very good. So this all just sounds great, doesn't it? But so I'm going to be 24 in about a week and a half
Happy
or so.
birthday.
Thank you very much. So why would someone my age need to know this information? When would I even need to come to you, say, and make a will? Is this information only relevant for people much older than myself?
I'd say as long as you're 18, because you do have to be 18 to do a will.
Yes.
You can't be a minor. Any adult should do a will. You don't need to be a certain age. You don't need to have a certain amount of assets. You're never too young. And there are some really good reasons why you might do a will even when you are young and even though you think that you don't own very much yourself. Firstly, you get to appoint who looks after your estate, who makes the decisions about, whether to sell your car or if you've got your first home, what to do with that. So someone to make those decisions for you, and even more personal decisions like your funeral arrangements or whether you're cremated or buried. Those sorts of very personal decisions are in the hands of your executor. So appointing an executor is one very good reason to do a will. Even if they don't have a lot of assets to manage as part of the process. But you also might actually own more than you think. So we've all got superannuation. That would be cashed out if you died. And quite often you'll have some sort of insurance policy, life insurance policy through your superannuation or default insurance policy. You also might be a beneficiary of, say, a family trust. If your parents have a family trust, they might have distributed money to you over the years, and you might have this unpaid present entitlement or this loan account in the trust, which is actually an asset of yours and does form part of your estate. So you might think you don't own very much, but in fact, at the time of your death, you might have more than you think.
Yes.
And if you don't have a will in place, you don't get to decide how that's distributed. So I can give you an example of my own children. I've got 4 children, 21, 19, 18 and nearly 16. And they would want, each of them, they would want their estate to go to their siblings, not to mum and dad.
Exactly.
Whereas if they died without a will, that's exactly where it would go. It would go to the parents, unless you've got a partner or children yourself. So if you want your estate to go to a boyfriend or friends or to siblings, then you would need to do a will to dictate how that's going to play out.
Could I leave even say like my superannuation to my sister, because I know you can create like nominate beneficiaries?
Good question. You can do a binding death benefit nomination, and as part of our estate planning process, we do look at superannuation and where it goes and making sure that an appropriate binding death benefit nomination is in place. But with superannuation, it doesn't form part of your estate unless you direct it to your estate or unless the super fund pays it to your estate.
Yeah.
And you can do a nomination to direct it to a superannuation dependent, but there's only a certain number of people that qualify as a superannuation dependent. They are spouses, and there are a couple of other exceptions, but generally spouses or partners. You don't have to be legally married, but genuine domestic partners, and children. Otherwise, you need to leave it to your estate and then distribute your super via your will. So a lot of young people, when they might be a member of Australian Super or something like that, will get their binding death benefit nomination, fill it out, and in your case, appoint your sister as the beneficiary of your super. That's actually invalid because you can't leave your super directly to a sibling or to a parent or to a friend or to a grandparent. There are only particular people that can receive your super directly. And if you want it to go to anyone else, it needs to go into your estate and be distributed as per your will.
Wow, okay. Well, that's very good to know. I have to go and update my superannuation nomination form then.
And the interesting thing is, and of course it would be logistically impossible to do this, but the retail and industry funds, they don't necessarily communicate with you that you've done it incorrectly or that it's invalid, because it would be probably impossible to communicate with every member to say, oh, you're not allowed to leave your super to this person, you'll need to redo it. So they just rely on the default provisions, which would then be that they get to decide. They'd probably leave it to the estate. But if you're wanting it to go to your sister, you would have to provide that in a will, because under the laws of intestacy, it wouldn't get to her either. So it is... it's not something that you'll be picked up on by the superannuation funds. It's incumbent upon you to make sure that those documents are in place, and that's why we help people with that as part of the process.
That's very interesting. So I guess assets these days, I guess, are more than just like cash in the bank, cars that you might own, pieces of jewellery. We live in such like a digital age. You know, people have cryptocurrency, shares, they have social media platforms. So what happens to all of that when I pass on?
Well, we've touched on a few things that don't form part of your estate, like superannuation, unless it's directed there. Any assets that are in a family trust will stay in that family trust. Any assets that are in the name of a company will stay in the name of the company. So with those other assets, it's about, with super, directing it where you want it to go. With those other assets that are owned by other entities, we need to make sure the succession mechanisms are in place to transfer control of those entities, because if you can control the entity and make the decisions about it, so make decisions about how things are distributed, what's invested in, etc., then you essentially can have some ownership quasi-ownership over those
Yeah.
assets. So we look at control with those things.
Yeah.
But you touched on a really important point in relation to digital assets because the law, it moves slowly. I mean,
Yeah.
especially in this area, in wills and estates, it's very slow to adapt to changes particularly with how much we've embraced technology.
Yeah.
So with digital assets, we're still catching up and it's changing all the time.
Yeah.
But historically, it's certainly getting better, but historically we've had to just do the best we can to deal with them via wishes because a lot of digital assets you don't actually own. You don't have any ownership over them. You might have a license to use a platform and yes, you might store all your photos there and that sort of thing, but how you access them, or a lot of it's not your actual property. You know, you're just using that platform under a license. So a lot of platforms now will have their own mechanisms in place to appoint, say, a digital executor. So, you know, say Facebook, you can appoint a digital executor.
I did not know that. That's very
and
interesting.
you can give instructions as to what that person's allowed to do. So whether they close down the account, whether it's memorialised, those sorts of things. But also it's important to let your executors know what you want to happen with those things. Do you want everything deleted? Do you want them to, as soon as you die, try and get access to all the photos you've got, you know, things that might be special and important for you going forward? What do you do with email accounts? You know, we've got such a huge digital footprint now.
Yeah.
That we need to look at all those different aspects and because there's no consistency with how they're dealt with, look at how we can deal with each particular thing. So we recommend that clients give as much detail about what they want in either a memo of directions or a letter of wishes, so that their executor knows what to do and knows how to access things and knows what your digital footprint is. And actually, I'm going to throw this back to you, Elektra, because I know that you've been instrumental in driving our new Aintree custodian platform, which we are just establishing to assist our estate planning clients in housing all of that documentation. So maybe you can take us through that because I know you're driving that process for us.
Exactly. Oh, thank you very much. Well, I guess it is there to because you have, how are your executors, your beneficiaries supposed to access all these accounts? Sometimes you'll have usernames that are going to change and passwords. So to leave like those access codes or leave them to your beneficiaries to access in the future, Aintree Custodian, it's like a online presence similar to say like Dropbox or Google Drive, but it is completely secure. It's like military grade secure, and it's available 24/7, and you can upload anything on there. You can put your usernames, passwords, you can leave instructions on how you want certain things, like as you were saying before with Facebook, where you want it to be memorialized, or maybe to close down some Tinder accounts maybe you don't want anyone knowing about. But also there for estate planning means, so you can put like your digital copies of your wills and your enduring powers of attorney on there. And you can even leave comments on there to say, so these are the electronic copies, but the original copies are held at Aintree Group Legal, for example. So it just makes it a lot easier for your beneficiaries and executors to manage your estate when you're gone as well.
And so how do clients set that up? I'm flipping.
Yeah, that's right.
How do clients set that up as part of the process?
When they do their estate planning with us, once it's all signed and all completed, we'll send them a link, and it's completely optional, and it's also free as well for them to do this. And they'll follow the link, create an account, and they'll upload all their documents, insert all the relevant information. And then they can also, say for like your will, you can assign people to access the account or when you die. So for example, you could link it to your executor's email address. So when you die, they instantly get access to all of these documents. And that can sometimes like save a lot of time and energy.
Yeah, because I know in the past there have been
Yeah.
situations where you just can't find things. You know, clients can't find things and they'll search through the deceased person's, their family member's home and filing cabinets, and they might not know which lawyer they used 10, 15 years ago. And one of the shortfalls, I guess, in Australia is that we don't have a common registry to keep your wills. And so I was speaking to a client the other day who lives in France, and in France they have a central registry. So you know that everybody's will is kept there, and if they don't have it there, then they don't have one because that's a requirement for it to be valid. And yet in Australia we don't have that. And so what happens is people will redo their will, and as part of redoing their will, it will revoke previous wills. And they might not do anything about that old will, so it'll still sit there at the other lawyer's place for years and years and years. But they might have then done a more recent will that then needs to be located, and there is always a risk that you can't find the most recent will.
And I guess that's handy with Aintree Custodian, because even if they make a new will, they've always got access to this platform. Once they've created it, they've always got access to it. And they can just re-upload the latest version. So there's people know that this is the most current version.
And I think having that security of information, so that because there's a risk, obviously, if you write all your passwords or instructions down in a little black book, that might fall into the wrong hands or be stolen, and people will have access then to your personal information. So at least if it is housed in a more secure environment, you don't need to worry so much about those things.
And I just have to quickly comment that we, as your solicitors and lawyers, we don't have access to this account as well.
Not unless
you give it to us, but it is just completely for you. Going on to, I mean, we were talking about wills and we were talking about enduring powers of attorney and medical treatment decision maker forms. And they only come into existence when we're alive.
Yes.
So can you talk a little bit more about why we might need those specific ones?
And I have noticed recently that those documents, so particularly the medical treatment decision-making appointment and advanced care directives, which are another thing altogether, that they're becoming a real topic of conversation. So I sort of see that as a trend at the moment going forward. A lot of people will refer to them as a living will. And it's basically setting out what happens while you're alive, but if you can't make decisions for yourself. So you might appoint someone to make financial decisions for you under an enduring power of attorney, or personal decisions for you under which will be things like where you live, for example, or guardianship type decisions if you need extra support around the home, care type decisions. And then the medical treatment decision maker appoints a specific person to consent or refuse medical treatment on your behalf. And that might be something fairly simple, like consenting to an operation, or you might already be in an operation and they need to do something else. But it could obviously be something really challenging, like turning off life support or those end-of-life decisions. So those documents are really important as part of the process, because if you don't have them in place, in relation to financial and guardianship or personal type decisions, you need to go to VCAT. A loved one would have to go to VCAT to be appointed. And then there are normally criteria around that, or requirements around that, to deliver up accounts to get consent for certain decisions. It's not as flexible and open. And with medical treatment decisions, yes, there is a legal sort of default hierarchy, I guess, that would appoint your spouse, say, and then oldest child and so forth to make those decisions.
So are you saying that I have to favour one child over the other when...
Yes, and a lot of parents find that really hard, because only one person can be appointed as medical treatment decision maker. So a lot of people will default to just go in age order, but quite often there'll be one particular child that is better suited to those sorts of decisions. They might be less emotional, or sometimes the parent wants a more emotional person making that decision, or someone that works in, say, the healthcare industry or is a doctor or a nurse or something like that. But they're the legal framework documents, but then it's also important to tailor them to suit your circumstances. So you can decide when they start. They can start from when you sign in relation to financial and personal decisions. When you sign the document, they can kick in.
Yeah.
Or you might only have them come into play if you lose mental capacity, if you don't have the capacity to make your own decisions as certified by a doctor, or if you instruct your attorney to act. And you can place all sorts of directions and requirements around how they carry out their role. The medical one will only kick in if you can't make a medical decision for yourself. And there are some things you can't delegate to someone else. For example, voluntary assisted dying, your medical treatment decision maker can't put that into place for you. You can't vote for someone else under your power of attorney. You can't force them to get married or divorced by power of attorney.
Okay. Well, that's good to know.
So there are those legal documents. And then there's also the wishes around that. They could be kept in somewhere like Aintree Custodian, or a lot of my clients lately have been asking about advanced care directives. I think with all the health issues that as a society we've had over the last few years with COVID, people are more mindful of what their wishes are if they're suffering from, say, a terminal illness or get to a stage where they don't have a good quality of life. And the complicating thing is that every state in Australia has different documents, different requirements, different witnessing requirements. In Victoria, that advanced care directive has to be done with your doctor. And that's what people will often refer to as a living will. Doing that document. So that's, I would say, is something that's certainly getting a lot more attention lately and is a bit of a trend for the future at the moment.
Very interesting. So what happens if, hopefully this doesn't happen too soon, but what if I've created a will and I have died? And so what are or say I've been nominated as an executor or beneficiary of under a will. What are my first few steps? What do I do?
Yeah, and well, the first thing I always say to clients is you don't panic, don't be in a rush, just take your time to grieve.
Of course,
I think a lot of clients will go into action mode and they'll ring the day after their loved one has died and say, Dad's died, I have to do this, I have to do that, where do I start? And my first piece of advice to them is just breathe. Nothing's going to happen if you just let things settle, just focus on the funeral and saying goodbye and allowing yourself the space to grieve. Then we can start doing things in the background. So the first steps would be to wait for the death certificate, which would be part of, the whole funeral, and that normally the funeral home will order that for you or help you with that. Once that arrives, which might be a couple of weeks, we find the original will. You do need the original will to apply for probate and work out what assets might form part of the estate, looking at all of those things we've talked about today. So, what personal assets they have, superannuation, other structures that they might have control of. So we gather all of that information and then in most cases, you would need to apply, not all, but you would need to apply for probate, which is like the legal authority that the court gives you to say, yep. The will's valid, yes, you're appointed executor, yes, you can carry out your duties and provide certain undertakings to the court about that. So there's a process for that application, advertising, lodging documents, but that's what we are here to do for you. So we would guide you through all of that. And then also hold your hand in relation to other things, things like mobile phones, or store cards or subscriptions, in things coming through into the inbox, and people want to keep access to a lot of those things too for a while. But it is very difficult and emotional and time consuming to be ringing up and cancelling all of those things.
Yeah.
We provide guidance to clients about that, but we can also do it for them if they would prefer that. Things like, I was just speaking to a client last night actually, and going into Vic Roads to cancel the driver's license. Like that's quite, and I know when my dad did it when my mum died, and he took her driver's license into Vic Roads and burst into tears.
That would have been really hard.
Yeah, it is. And so that's what we're here for, to guide our clients through that process and provide them with the support and also the personal support they need. And I think that's our point of difference is that we do lawyer with heart and really get to know the clients and are here for them.
Yeah. Well, that all sounds very lovely and very helpful. So if I am looking to find an estate planning lawyer, is there anything that I should look out for that you would recommend in an estate planning lawyer?
Well, obviously, I'd recommend you come to us. But there are lots of really good estate planning lawyers out there, and it's actually a very collaborative community where we share precedents, we share information, we share knowledge, workshop ideas. There are some really great conferences out there where all the estate planning lawyers will sort of get together and share that information, which is really valuable. So there are a lot of really great estate planning lawyers out there, and there is a lot of work to go around. So I think generally estate planning lawyers aren't territorial of their work because as long as the clients are looked after by someone, quite often we'll work in with other lawyers. So I've had a couple of matters lately actually where another lawyer has done the will years and years ago, and so they've had the original will, and quite often the loved ones will stick to the same lawyer who holds the will, in their deeds. And I've had a couple of clients lately where they have it's been simpler to go through that process of obtaining probate through that lawyer, but then we'll work in with that lawyer and pick it up once probate's been granted, and then do the hand-holding and the estate administration, particularly if there is setting up testamentary trusts, which is probably a little bit more sophisticated, and not all lawyers do that and not all accountants do that. So it's important to find a lawyer that does work in with their accountants and financial advisors in relation to investments to support that whole process in not only setting up the testamentary trust but then managing it in the future.
Yeah. Speaking of the future, what do you think that the future trends of estate planning will be? Do you see any changes? Because I know you were saying before that wills and estates was very slow with technology. Or coming up to date.
And I think COVID fast-tracked that a bit in that there were measures in place during COVID where wills and powers of attorney could be signed electronically. But particularly in Victoria, the process is very convoluted. You need to record it via audio-visual link. You need to be able to see what each person's signing. And there have actually been a couple of cases since then where wills have not held up when the application for probate has been made, when they've been signed electronically during the COVID provisions. So even though there is that option there, it's not really used. At the moment, we still sign everything in person. It's also important to explain the documents. One of the criteria for a will to hold up is that the testator, the person making the will, understands what they're signing and knows the contents of the will. So that's very difficult to ascertain via an audio-visual link because you don't know if they're being influenced by other people, if other people are in the room, what the circumstances are. You just don't get that same feel for people. So I think that is something that's definitely very topical and a trend of the future, digitising the process. There are certainly a lot of online platforms available, but I think the witnessing part of it, the actually putting it in place, is still taking a little while to catch up. So I think that's a hot topic. As I said before, living wills or advanced care directives, there's a lot of talk around that. And people are becoming much more sophisticated in their knowledge. You can find out so much information yourself. So a lot of clients will come already armed with ideas and information and a good base foundation knowledge of what an estate plan is. So I think bespoke planning and tailoring estate plans for the particular client, I think that's where we add the most value. The actual documents, they're just the legal infrastructure that supports what the client's trying to achieve. But the real value is in developing the strategy and putting that structure in place rather than drafting documents. And I think that's where the future lies and where we as lawyers can add value to the clients.
Yeah. Well, thank you very much. Thank you, everyone, for listening. I hope our discussion today answered some people's questions, I guess.
Yeah, we covered a lot of material.
We did cover a lot of material. So hopefully we haven't lost anyone in that. But if anyone has any questions, they can always contact us. Yeah. And if we're lucky, hopefully some of our listeners we may get to meet one day. And Sophie and I could do your estate planning.
Well, thank you, Elektra. And yes, by all means, reach out if you want to discuss anything or if anything requires further clarity. There are also quite a few articles that we have online on our website. Yeah. And I recently did an estate planning seminar for our clients and team members in our office, which has been recorded. So you can always reach out and we can.
I just watched it.
Oh, okay.
It's quite good.
There you go. It's on YouTube. So you can also check that out, and that probably deep dives into some of these topics we've canvassed today in more detail.
Yeah.
But otherwise, thanks for listening, and I hope to meet you.
Yeah. Thank you.